Okay, so how do you argue against likelihood of confusion? Well, you want to draft a proper legal argument supported by case law. Case law is your evidence here. Remember that the jurisdiction is the TTAB and federal circuit cases and Supreme Court cases. Don't cite state trademark cases and other federal court cases from other districts. They have no persuasive value. So everyone knows there's the 13th DuPont factors. You don't have to argue all 13. Pick the ones most relevant to your case. So you have sound, appearance, commercial impression, relatedness of goods and services, similarity, dissimilarity of trade channels, sophistication of purchasers. These are the most common ones. That's not to say that these are the ones that will always apply to your case. Maybe some of the other 13 DuPont factors will apply, but you don't have to argue all of them, I promise you. If you're arguing dilution, meaning that the field is crowded, that there's a lot of marks coexisting, remember that foreign registrations don't count into this argument. So you want to make sure you're attaching your test printouts as evidence, and you have to note the actual evidence of use in commerce in your dilution argument. Otherwise, you're not going to be persuasive to the examiner. If you want to argue against similarity of the marks, right? So if you're arguing, Acme and, Acme Light, just pulling examples. We're going to talk about a few examples here in a second. Argue whatever you can. This is where you want to be creative. Is it 2 words versus 3 words? Is it the number of syllables? Is it the addition of an S? I want a case on that, by the way. I'm going to show it to you in a second. It's not always going to work. This isn't just throwing stuff at the wall and being lazy about it. It's really coming up with an intelligent argument. For similarity of goods and services, really look at the examiner's evidence and look through the database. Use real world examples. Think about how you as a consumer interact with these goods and services. Are they likely to be encountered by consumers side by side? Give the examiner plenty of evidence to support your position. He or she gave you plenty of evidence to support their position. You want to counterpunch it. That's your job. Sophisticated purchasers. Are the price points the same? If not, if you've got two products where one costs $10 and one costs $100, well, those are very different purchasers, consumer purchasers. One's sophisticated, one isn't. One's maybe an impulse buy and one isn't. Argue that. Are the channels of trade different? But you need to talk to your clients. You have to really understand the client's goods and services and their go-to-market strategy. You can't figure this out on your own, I promise you. You have to talk to your client. You have to really understand their business. And then if you're going to argue that the marks are weak and dilute, then that's easy. If there's already 8 or 9 citations, why can't you coexist too? Well, you've got to give the examiner the evidence. You've got to print out all those tests marks and show why you should also coexist. You have to show that they already exist, not just that they're registered, but that they exist in the marketplace.